Hello, all viewers. Welcome to another podcast, an exciting series. We have a very interesting subject today. We'll be talking about the public trust in the Indian judicial system. First of all, let me apologize for the late start on the topic. We had some technical issues. So, without further delay, let us start with the topic. We have a very interesting speakers on board today. So I welcome Dr. Viri Swami sir. He's a legal scholar and a researcher. Welcome, Viri sir, for the podcast.
Hi Naveen,
Hi.
everybody.
So we have Manjunath MP. He's a legal researcher and scholar again. He's a well-known law researcher. Welcome, Manjunath.
Hi, Navin. Thank you.
So we have Sham sir. He's a jurist and also a distinguished social activist.
Hello
He
everyone.
has been right. He has been a role model for many people. Welcome, Sham sir. So, without further delay, let us start the podcast. Over to you, gentlemen. Yes, Manjunath.
Yeah, thank you. Good evening, all. Hi, Viri sir. Hi, Sham sir. To start with, the topic public trust in the Indian judicial system, which is a very big topic and which is very important. The public interest in the judicial system, the thought sparked and a doubt arised based on the recent slogan uh, which we came across, justice is due, which has sparked a massive social movement across the countries, which has raised significant questions about the Indian judicial system now. And also, we see a severe backlash on public on the operations of the Indian judicial system and its accountability towards the society as well. And when we say judiciary being one of the three pillars of democracy in India, along with the legislature and executive, which is to uphold the rule of law. Uh, Judiciary is the only pillar on which the common man today had an hope, because that is the last hope where a common man waits or seeks justice. Because we all know that legislature and executive being exposed, so in the recent times the judiciary is getting exposed. So with that sense, when we think about, okay, when we say judiciary is being the temple of justice, and and why this social movement came into picture, and do public really have any trust on judicial system? So that's where, if we dig on to the subject further, when we see the pending cases across in India, as per the Niti Aayog, in its report, Strategy for New India at 75, the report which was published on November 2018, that states that a study carried out by Ministry of Finance found that it takes on an average almost 20 years for a property related dispute to be resolved, and it would take 324 years 324 years just to clear the current backlog. Just to clear the current backlog, it would take 324 years. And if we see at that point of time, meaning at the end of 2018, what were the total number of cases pending? It was 3 crore 51 lakhs. And if we see it today, as on date, it is 5 crores 21 lakhs. So if we go by that report and apply the same analytics what they have applied, as of today it would take 492 years to clear the backlog. So that's where a thought triggered: is justice is a myth in the Indian judicial system? Is that judicial system has collapsed, and and seems that uh, it's gone beyond repair? That's what we can sense it. So that's one aspect with the Niti Aayog report and current pending cases. And also, Yeah, on this, I would like to hear your views, Shamsar.
Thank you, Manjunath. First of all, thanks for bringing such a valuable insight. Uh, I'm puzzled. It has shocked me, and somewhere I don't know what reaction I have to give. Should I laugh? Should I smile? Should I say that anybody who is actually in dire need of justice, should they live all the hope and go back and surrender to the injustice that is happening in the society? Right. So justice is due uh, is not just a slogan now. After the data that you presented, it looks like justice will always be due. Okay. But I was looking at the other side of it. I was looking at saying, are we so incapable to handle such a large pileup of cases, or have we done a grave mistake of creating certain laws which are not totally black and white? So, as per my understanding, generally a law need to be curated in such a way that it has to be black and white. It has to be very clear. It has to be unambiguous. But somewhere in giving some benefit to certain segment in the society, somewhere to have something catered to a very very special category in the society, we have tried living gray shades in law, and this gray shade is causing such a huge delay. Number one. Number two, when you call out that 492 years it will take to clear the backlog, I was just doing the math in the background. Take 78 years on average life cycle of a person here, right? Which means after generations, someone is expected to receive the justice. So in Kannada we say, right, Yolu Janmada Anubandha.
Yeah.
It looks like if someone enters the court, then he binds himself for that seven cycles of life. So it is very very disheartening as a citizen of the country. I literally feel pained to even listen that we have such a huge pileup. I am literally pained to even think of real victims who enter the court premises expecting that justice will be delivered to them. And I also learned in my early age that justice delayed is justice denied. So if I am projected that it will take 7 life cycles to get justice, then it is not just delayed, it
Yes.
is dead reborn, and I don't know when exactly it will be delivered to me. Very very sorry state, but I would like to hear more from Dr. Veeri, because I know that Dr. Veeri would bring a lot of other insights to this, and it would be very interesting to listen to him, and then we can have our own conversation and own dialogue on this later on. Dr. Veeri, over to you. Dr. Veeri, you're on mute.
Oh, sorry, I did not realize. Thanks, Sham.
Thank you.
Thanks for handing over. Manju, great work in collecting the data and feeding it and coming up with a concise report what you have done. Really great work. I appreciate that. See, particularly the question when it comes, particularly the public trust in the Indian judicial system. Basically, our judiciary literally depends and runs on the public trust. If they don't have public trust, then what would they do? Would they be even operational? If we don't go, this is one of the key points that we have to see. The core principle that we run is it's kind of a natural resources like the rivers, the air, the forest. Similar to this, the government has to trust the public, and the public have to trust back the governments, manage, give the managed position and resources to the people of its country. Now, in Indian judiciary, which we are more on the adversarial kind of judiciary system that we have, it has got often used its own judicial purview to enforce the public trust. We have believe me, the judicial system also has got something called as the public trust doctrine, which they now and then keep coming up and trying to imbibe or pursue it into the society wherever there is a particularly any environmental cases or the NGT, that what they call. So these are all the organizations or the sub-judiciary, quasi-judiciaries which come into the public domain and give the public or earn back the public trust that is lost. So by trying to conserve the natural resources. Similarly, when it comes to cases, be it criminal or civil, as earlier said, like one of the property cases runs up to 5 to 20 years. Yes, it happens. We have seen there are cases which have run almost for 40 years too. But one-off cases, yes, it could be there. But agreeing to your fact that off late, when there is more of a false cases that is getting registered and judicial time is getting wasted in 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 a very trivial matter. For example, there was news which I read yesterday or today, where one of the court was hearing on a case of a wife filing a case on a husband, a criminal case on a husband, because he rather was more concerned with a cat or petted his cat more than spending time with her. So see, when something like this happens, it should be cut short at the bud level itself. You should not even reach the matter to high court. It should have been done at the lowest possible court matter. This is what these kind of cases come up and clog the judicial system, and judicial clock stops at that point. And believe me, if these kind of cases don't even come into the room of the court, then obviously you will not be saying this what we are today saying with her. Of course, because of these kind of false cases coming out, it's clogging the judicial system. The judiciary is overloaded at this given point of time, so thereby the public trust is slowly declining. We can hear it out in the public crowd saying like, oh, what will I get if I go there? It's just I'm going to waste time and do it. So now again, I think the judiciary has to visit the doctrine of public trust and make certain changes in that to regain the trust that they are slowly losing. And if it is not arrested, the loss is not arrested at this point in time, then believe me, there people majority would lose the trust. Of course, to do that, gain back the trust, every judicial officer, every officer of the court, starting from the lowest clerk level up to the justices, will have to strive hard to get back that. And so that's my opinion. Judiciary is losing its trust from the public, and it's high time, or we are coming to the close point of where it's going to be called as, and it's high time that we look in ourselves and then change or accept the doctrine of public trust and then regain it going forward.
Yeah, thanks, sir. And this is with related to pending of cases which has clogged the judicial system. And the one more interesting fact is that the Law Commission of India, in its 120th report on manpower planning in judiciary in July 1987, I would like to stress this, in 1987, observed that strength of judicial officers in India were 10.5 judges per million population, which is far, far less compared to other countries like Australia, where it is 42, Canada, where it is 75, England, where it is 51, and United States, where it is 107. And the Law Commission did propose and also recommended to increase the ratio of judges per million of population from 10 to 50, which was in 1987, they recommended. And today, in 2025, where we stand, so we are nowhere uh, nearer to 50. We are around 21 judges uh, per million, which is not even half of what law commission suggested, which was way back in 1987. So it's been 38 years, and we have not even reached to that, nowhere near to that recommendation made by the law commission. That is one aspect. And second thing, with 21 judges to population ratio per million, high court and the subordinate courts not even running in its full capacity, even for that 21 judges to population ratio, whereas high court is running at only 67% capacity, and the subordinate courts are running at a better rate of 79%, which means that even though when we say 21 judges to population ratio per million, uh, with these vacancies it's still less. So would like to hear more on that from you, Shamsar, to start with.
I have bit of a contradictory view on that. See, tell me one thing: will any good society where you have good uh, legal bindings and morality existing, do you encounter any issues where you think that court system is actually needed? Ideally not, right? Answer is,
Yeah.
if the society becomes moral, then you don't need the legal system. So I think Dr. Veer brings a very interesting line where he talks about public trust doctrine, right? And I remember very well saying, belief of a common man when something goes wrong, when he feels that he doesn't have any power, that is when he says, I will see you in court. That used to be the trend, which means a common man always used to believe in judicial system. He always used to say that whoever powerful may be behind anybody else, but I have belief in the system, and I believe that I will get justice. That is why he used to say, I will see you in court. Today, is it so easy to say that I will see you in court? If this data is brought in front, if this data is kept and said that with all the things that are happening, huh, 21 judges for a million people, and we have lakhs and lakhs of cases pending, crores of cases, not even lakhs, then the person will say, come on a sideline, we will try to compromise something, talk something. I know I will get injustice, but I will try to compromise and get it settled. So is that setting a real good precedence? Number one. Number two, by doing that, are we not encouraging injustice to happen? So, Junior King Martin Luther Jr., right? He had said a very good proverb. He said, injustice anywhere is a threat to justice everywhere. Now, I'm just rethinking that somebody who is in dire need of justice, somebody who believes he was on the right path, somebody who believes he was a good citizen of the country, and he did everything possible in his hand to play the role that he was expected to play in the transaction that was happening, and he feels that he has been victimized, he has been oppressed. That is when he generally used to say that we will see you in court. But now, looking at this stat, looking at the number of cases, looking at the less number of people, at the same time, looking at the rate of increase of false cases and unwarranted, silly, joke related cases, which comes to judiciary now and then, saying my husband loves pet, my wife loves this, my husband doesn't share his toothpaste. So I think these type of funny cases also consume lot of precious court time. Somewhere we have misevaluated that where we are progressing. If a country has to develop, the first thing that it has to set right is its judicial system, nothing else. Because if the judicial system is right, it will bring inborn morality in the society, the morality in the society and the legal framework in the society that will keep people on the right track. People being on the right track will not waste time in unwarranted things. They will try to contribute to the growth of the country. That is how from a developing country you will become a developed nation. But if this stat is put in front of any common man, and if he is said that probability of winning those cases is 0.0001%, because rather than winning, I would say probability of getting the justice, if he is looking for justice, is 0.0001%, then whether he even thinks of a legal system existing in the society. And the other side is, forget about someone who is a genuine victim and he's going to the court. Think of the moral boost that happens to people who are doing injustice. They have to bypass those 99.39s or 49s probability to even get caught once, which means in 1 million proposition, the chance of getting caught is 6 sigma. The legal system has opened up a 6 sigma standard to catch culprits. Really a funny situation. Though it brings smile on my face, I'm really broken inside. I really don't know what to comment, what to say, and where we are living as a society, where we are progressing. There is an opportunity to bulk close a lot of cases. There is an opportunity to use today's technology to improvise on this stat and introduce processes and systems in place which can speed up trial. Speed up trial doesn't mean that open court 24/7. You're already making people wait in front of the court from morning 11 o'clock to evening 5 o'clock. Doesn't mean that you make them wait for the whole night. Okay, we do have a lot of mechanism where it can be achieved, it can be done. One thing which our legal system should do is open up and embrace a lot of new talent. We have wonderful new talent. We have wonderful enthusiastic people who are in the market, who want to contribute to this system. And it is not only contribution as a presiding officer or a court officer who can support, deliver justice. It is in multi directions. It is a multi dimension thinking that we need to improvise the system. Only then, as a country, we will be able to overcome this problem. Else, believe me, that forget about becoming a developed country. It will be very hard to even be in the developing race, because your people, only when they feel safe, only when they feel that their contributions will be valued, they will come to the mainstream and contribute. The moment they feel devastated, the moment they feel that they can undergo oppression and no one else will be there to save them, and the moment culprits start feeling that there is one probability out of 10 lakh permutations to get caught, he will very easily take that chance. That is what I want to call out. Over to the panel. Dr. Veeri.
True, Sham. I agree with what you said. I bring everybody's attention to the statement which you quoted by Martin King Luther. Uh, that's a very good statement. But see, what happens is when we look at it from that statement, why injustice exists and why justice exists. So when there is light, there should also be darkness in the absence of it. So when somebody says, I will see you in the court, is he really seeking justice or is he just really seeking to trouble the other guy? That's has to be first level of evaluation has to be done that. The moment the first level of people who have to evaluate that fails to do it, that is the point where you have started to clog the system. You are one of the spoke in the system who is starting to clog. That should be avoided. So to avoid that, of course, there is a certain amount of independence that has to be given to the judiciary, which has been already given. It's a large amount of judiciary across the globe. Every judiciary system enjoys that freedom to be on their own. So the moral authority, if you see from the system or the society, is eroding as we are seeing more. The moral system, moral authority of the society is eroding slowly. We can see that be it in social media, which recently made up news across, and there was a hearing on the Supreme Court even to say, that was a bad statement that were made on that. And not to coming to Indian judiciary, I think we should also explore or look into the practical limitations. What happened? So Manju was telling about 1987 or 84, the report that come and Niti Aayog, and we had about 10 per million or 20 per million taken. That's taken. But if you look at it, in 1984 up to the 19 late 90s, we had every person looking at either entering a medical graduation or only going into the engineering field or into the science segment, because that was the only hopes or that was the only thing for next earnings or making up a life. So, how many people came up taking up a line or a subject that would lead them to judiciary, or lead them to social responsibilities or cultural relativism? How many people have done it? So, nobody. So, let us uh, give that from 84 to 2000, almost we should have to neglect that count. We Nobody moved there. Only in the late 90s and the early 2000s there were other opportunities, global opportunities that came up in the other fields of studies. That is where people have gone ahead. And the the first level of court officers or the advocates, that like me and Manju, who are the ones who are in there, so we don't know what lacks there. They should be the first people who should tell the clients who approach them how long it would take, and it would not be reasonably well if you go, and it would drag and it would make him lose his mind, the peace of mind, and also his monies. So if you look at well developed countries, we don't have this kind of situation. Most of the time it is always, even in the criminal matters, there is an offer of plea that is being given. Either you plead guilty and take the punishment that is awarded, do community services, or whatever it is, or monetary reparation that you pay and you get away with that. That's one of the. In civil matters, it's straight away rule saying like you sit across the table, both of the advocates meet, they come up with some agreement, and they decide there and they settle, because everybody opens up their evidences in those meetings. But here, even with you have evidence, you have to go to the court, present it, and there are dates, and that takes a longer time. So this is what, when there is, this is what you told as, justice delayed is justice denied. That's where it comes into picture. And once justice is looked or presumed to be denied, that is where we say, that is an injustice that's happening to me. So
Exactly.
anywhere that is injustice happening to me, that means to say everywhere there is a injustice that's keeping. So that becomes a threat to the justice system itself. Now, if you look at it, who all can play a role here? Society by itself, by large, educating, holding itself responsibility to certain changes that it has to accept and adopt in the growing cultural aspects of life. And then there is the role of media and technology. Media always projects the negative. Should come back and say like, let us look at the positive part of it. And there is individual responsibility as a person. You, everybody have to pick it up as an individual. And there is also the international organizations that come together to sit together across a table. Like we have G20 investors meet, you have got Davos meet, you have got multiple other things. So I'm not aware until so far that whether there is an international judiciary meet that happens timely, and they come up with saying like, we have these kind of laws. Can you accept these kind of laws? No, I don't think so, because I came off late recently when I was studying my law. I came to know like in most of the part of Europe and the developed countries, you don't have anything law that is called as similar to 498A or DV, which is one-sided. There, everything is gender neutral. Now, there are challenges to that. If a person is outside of India, how do you bring back under these penal codes? So that, let me not go in there. But coming to back to the injustice and the eroding trust on the this thing, I would say like me, Manju, and people like you, being from the society and social activist, other members of the organizations that multiple NGOs are there. They should take up certain responsibilities on the social front, educate people, and say, like, you will obviously, your trust on the judiciary will erode if you start filing up these kind of frivolous and unwarranted cases. Go for a genuine cause. You lost your limb, insurance doesn't pay you up, go, make them pay for it. But if you are just going because, okay, I just threw garbage into your compound, then want to file a case, no, that doesn't really worthwhile. And that's where I say it is an individual responsibility. One, individual responsibility. Then there is the collective social responsibility, and there is organizational responsibility. We have to collectively be responsible for not clogging the system, thereby making it open enough for people to approach for genuine reasons, thereby increasing the trust of the public on the judiciary. That would be my take.
Yeah.
Wonderful,
And
wonderful.
also, sir, as you mentioned about certain meetings, have they grouped up or conducted any kind of meetings to address these issues? Uh, One such on February 1st, 2025, first of this month, there was a national conference on addressing issues faced by the state judiciary, which was organized by Supreme Court of India under the guidance of Chief Justice of India. So soon after that conference, with the Chief Justice of High Courts and senior most judges of High Court, they did discussed about the filling up the vacancies in High Court and appointing ad hoc judges as well. And one interesting thing they came up with, that establishment of union courts. Um, so so I was like, okay, uh, what kind of things they are bringing up again? Uh, so your take on that, so establishing on union courts.
I will respond to you that on that, Sham. Before you go, I know you are. I know where you will lead it to.
So,
See, just because yeah, it's something like this, like, Bangalore being a city which has grown tremendously in the last 20-25 years, where the information technology and the biotechnology industries grew. So there we have around the clock working environment. So when you start looking at this, so you need food, you need transport. Basically, these two are the elements to reach from your workplace to home place. And then at the night when you're coming back, you may need something to eat. So why I'm giving you an example. When you look at it, when the system, or not exactly the judiciary, but one of the systems of the state went and approached the restaurant owners, why don't you just run it 24/7? You will make more money, you will employ more people, why don't you do it? The response from the restaurants were negative. They said, we don't want, because one is my labor costs increases. I don't have time to manage those labor costs because I run it from as a family business, so I wouldn't be able to do it. When such is the case that it happens, do you think the judiciary can open evening courts? How effectively it will be? If you are coming to matter of traffic related offense, maybe it can happen. I agree with that. Establishing evening court purely works. But when there is a lot of evidence that has to be read into, go into, who will do the night shifts? Can the judges do the evening shifts? Will they be efficient? That we will have to look into it. How much it will be, and will they be sensitive about the issue that has come in front of them? So, after all, judges are also humans, like me and you. Though we may not be sitting at the altered chair, but they have a power, and they also have to analyze. If there is a list of 100 cases a day, and even out of that 20 are heard, and they have to go through each and every documents of that, they are also human, they have emotions, they also sway between the talks. They have to absorb what each one is spoken to, and analyze that, and then come out with this thing. So would it be very effective to do that? So certain cases, yes, I would agree. Evening courts would be good. For example, the traffic, what I said, then any cases with respect to educational institutes. Some schools have increased the fees, so I want to challenge that. So those kind of things, administrative tribunals, for example, within departmental inquiries, they are challenging those kind of things. Yes, it could, you could run evening courts for that, because anyway the officers who have been challenging that will be working during the day, they can't come, so evening could also effectively work for them. So they can identify those kind of cases or those kind of subject matters and assign it to certain particular courts, which will surely work and benefit on an overall level. It will bring down the cases that has been pending for longer time. Your take on this, Sham?
Thank you. No, that is a very nice perspective. I think you were able to put that because you are a researcher in that area, right? So you look at the positive side of it. There is one drawback that I carry. I look at something which is not working, and I try to learn from that, and I try to see how it can be made to put to work, right? So fine. See, in your earlier conversation, you said something about freedom, right? Uh, Freedom has to be given so that they feel empowered. Freedom has to be given so that people feel empowered to do what they are expected to do in the society. That is the core base of freedom. But I am always of a opinion, or say, my principle is freedom without responsibility can be a very good reason to spread anarchy in the society. So I believe that freedom should be there, but that freedom should be with responsibility. Now, that responsibility is on ourselves. That responsibility empowers me to rethink what I have done is right or wrong. So I'm not diminishing the efforts that have been taken by our judiciary to speed up things to deliver justice in society. See, very wonderful, innovative ideas have been brought up. Even the government and judiciary both have worked together to put e-courts into place, right? E-courts itself is a revolutionary idea. And trust me, if e-courts would have worked in the way it is expected to work, they are expected to work, then it would have taken a lot of burden. But somewhere while implementing e-courts, we missed one very important factor, that have are we enabling right skill set in the system to make e-courts work more effective. Few of my friends who speak to me, they generally come to me saying, I want to submit one application, and e-courts doesn't provide me that option. I want to put one application, but somewhere the presiding officer is not accepting that. And I say, sir, you accept and reject it, but they say, I will not even accept, go whatever you want to do, you do. Okay, sometimes it happens, it do happen. But think of someone who has to travel way long. Dr. Veeri called out a very good sensible made a very good sensible statement. Evening traffics, you avoid evening traffics, you make people be available there. But when we are talking about e-courts, which is remote, which can be handled in a sensible manner with a lesser set of people, that itself has not worked to its optimal effort. Have we done retrospective to understand why it has not worked and what can be made to make people's life easy by correcting that? Number one, I have not seen a report which has published what are the issues in e-court and how that can be addressed. It could have been extended to districts, smaller talukas as well. But has it been done in the way it is expected to be? Answer is no. That is number one. Number two, when we talk about law, right, there is a proverb by Pluto once again, where Pluto says that good people don't need laws to tell them to act responsibly, and bad people will always find a way around the law. Okay, which means somewhere there is an intrinsic understanding that in the society, if you have morality, then you will act responsibly, and you will automatically address things in the right manner. And if you have determined to act immoral, then you will always try to find a loophole in the system to come out of it. That is where this delay gets extended, right? So Dr. Veeri brought a very good point saying we need to make people and the society more responsible. Society need to elevate and become moral. But will it happen within a day? Will there be a avatar whom we can expect to take birth in India once again, and suddenly one night 12 o'clock the bell rings and everybody gets an elevated mindset from 12:01 onwards we all should act morally? Will it happen? No. You should not lose the hope. It may, but that sounds more filmy, that sounds more dramatic, that sounds more of some yug which has to take place, right? Remember, even during the time of Ramayana and Mahabharata, the oppressor had to be fought to get justice, to put things in line. These are not just stories, they are life changing models for us to implement in our life, which tells us that we need to fight for justice, we need to fight for our own freedom, we need to fight to come out of oppression, because oppressor will never give you freedom, he will never let you go anywhere, else the freedom struggle wouldn't have extended so long, right? Now, when we are talking about evening courts, we are talking about setting up an exactly same system that is existing in for the day courts today, which means same set of working staff. You need to have a presiding officer. It is not just that a presiding officer coming at 11 o'clock to 5 o'clock doing shift is asked to extend another 4 hours. See, we need to respect that they are human beings. We need to respect the effort that gets onto their mind. Each case is a effort that they have to put. It is a total energy draining mechanism that they have to undergo. If one has to really deliver justice, fast track courts sounds very interesting, but can you fast track justice in the way things are being evaluated? Have we done any retrospective to understand the efforts which have been put to make e-courts, alternate dispute resolution system, which we generally know it as ADR mechanism, and fast track courts? Are these three things even working? If they have not worked, have we understood what else can be done to make it work? Now, on top of this, on top of these failures and these gaps which have made the system not work so efficiently, right? We do have infrastructure challenges, we do have procedural challenges. See, the system itself is made so complex that most of the time a common person doesn't even understand certain law exist. Forget about getting into property. You said someone fighting a property dispute has to wait for 20 years to get some justice on average, right? And if we have to clear the backlog, you said nearly 492 years. I would say approximately 500 years. That is what we are calling out, right?
Yeah, it's
Now,
like 5 centuries from today.
five centuries. 5 centuries. My goodness. See, with the changes in technology, with every 5 years, there is a revolution that is happening which is equivalent to a century. So I would see that not as 5 centuries, I will see that 500 divided by 5, which means so many centuries multiplied by centuries.
Correct.
So much of innovation, so much of things are happening, it becomes very, very difficult to cope up. People will find new ways, people will find a lot of lacunas in the system to overcome. I was i was just few days back, I was going through one of the video clipping in news. I need to recall which segment it is. I think one of the BNS section has uh, has a clause which says that some percent fine or 7 years of jail, something like that, where the jail should have been optional. They made the jail as mandatory, then or as fine they kept it. So this is what happens when you try to do things at a very faster pace. You overlook nuances, you overlook things which can be chalked out in a very cleaner manner. Forget about all of that. Marital laws: every male born, every female born is expected to get into marriage life one or the other time in their lifetime. At least 98% of the population today, we will exclude 2% or say 5%, 95% of the population at least gets into a marital life. We have failed to make clear procedures even for marital laws. Common, something which a person takes birth, lives life, get married, dies. There we have failed to formulate clear laws. How can we touch exceptions? How can we touch some other things which are genuinely broken? That is what I look at as. If I don't understand what is law, what is the point in even thinking I will get justice or not? Law should not be made to keep it in good books with hard bind. They look decent, they look nicer. Law should not be kept just as articles, just as segments. They should be percolated in the society so that common public understands it. There should be forums to educate people on laws. Only then people will become self-responsible. So that is where what Dr. Viri was telling, that socially we need to elevate ourselves. That can be done only when you make people understand what laws exist and what is right and wrong in the society. And laws need to be unambiguous. You cannot live a lot of gray shades in law, and you cannot punish people on gray shades. Gray shades will be people's self understanding by their own experience. If you had a bad experience with certain situation, you will always look that situation in that bad manner. If you have come across a very positive situation, then you will always try to evaluate that situation in a positive way. Law should not be according to your or my mindset. Law should be common. Law is not democracy. Law is morality. Even if 99 people say and do wrong, law should be upheld, and it should say, morally, I will punish 99 people, and I am standing that one person who was oppressed by 99 people. We as a country has done amazing things. We have done that. We have revived our laws. We have reinvented, and we have brought in new laws. We have made many corrections. But what I am trying to say is the pace at which we do it is very slow. We need to increase that pace. The talent that we have and the talent that we are attracting is very, very less. We are only looking at legal fraternity. There are many jurists who can contribute to the positive side of legal system. There are many social activists. There are many thinkers who can contribute. There are many people who may not have an designation called advocate, but they have a legal mindset. They have an activist mindset. So someone who is having a legal mindset and an activist mindset, they will contribute much better to these systems than someone who is professional in that system, because a professional is thought to be staying in the framework. He will not go, it will be very difficult for him to go out of the framework and think. He has been taught in that framework. But researchers like you and Dr. Viri, people who really care about the society, they will have the activist mindset to bring in different perspectives, which can really benefit the society, which can really make people overcome the challenges that exist in the society. Now, that raises a very, very important question. If we have to rate today, or if we have to evaluate the judicial efficiency and the sensitivity for justice system in our judicial legal framework, where and how we can rate ourselves? Very, very big question. Very big question that I always feel it is unanswered. And I don't have the courage to go and rate our system because I don't have any data point. When I don't have any data point and I have only numbers to say there are so many cases pending, what else I can do? Over to the London
True.
panel to especially
True.
talk of efficiency and sensitivity.
Well
Yeah.
put across. But when we look at it, Manju and Sham and the audience should start thinking out, like, why this has happened. So if you look at it, the latest reports from an international journal, the judges, I'm not going by the population, what Manju has referred earlier from the earlier report. I would rather go by the number of cases per judge. Let us look at it that way, how much he is going to handle. If you look at it in the country like Britain or the UK, we have for every 10,000 cases, we have got 15 to 16 kind of judges. In Canada, we have got somewhere around 22 judges. And in India, if you look at 10,000 cases, for every judge, there is 10,000 cases, like 46 judges are there for 10,000 cases. We are the highest in that way, if you look at it. Per 10,000 cases, it is higher. But the problem is why we can't finish those cases. Why we can't finish those cases? That's because we have got one, the adjournments that is sought by both the parties sometimes non-appearance of the parties, sometimes non-appearance of the councils. So now, as Sham referred to, Indian judiciary has invested a lot of money into the upgradation of their IT infra, and e-code systems have come into picture, and now video conferencing also has come into system. So now the courts, it's high time the court starts using these systems whereby you don't give an adjournment. You say like this was the date set, you better present yourself, present your side of the case, and then let us be done with it, rather than say I give you 3 months, later date. Of course, I've come across people reasons giving like, it's the lady couldn't come because she had a woman's problem today. This is the kind of reasons that typically an counsel is giving in the courts. Or the lady was not well, she had to care for the child. The man couldn't come because he had to go to his office because he couldn't get leave, or the council himself has got a marriage at his family, so he couldn't come. So these are the various reasons. Now, in these kind of reasons, enable the system to receive the presence of the advocates or the court officer via a video channel. We conduct business, we can see the multiple MNCs who are paying multiple taxes, huge amount of crores of taxes to the government, do their business over the video calls, morning till evening, night shifts, night time working, afternoon time working. We sitting in India, we are managing most of the data centers across the globe. So why can't the councils appear through video? Now, that is one part where you can technologically utilize what is being available to judiciary. Second thing is separate the cases and establish codes for those kind of things. Now, if you see in India, I'm just referring to from the handful of cases that I've come to know. If you see the in Bangalore particularly, the MMTC codes, that is called as Metropolitan Traffic Codes, they handle DV cases. Now that was established for traffic courts, but you are handling DV. Why don't you establish traffic courts in the evenings and say like mornings, let them handle all the DV cases. Let them move traffic cases in the evening, because anyway, you're caught either going home or coming back. You have to pay fine. Either you're drunk and driving, you have to just pay the fine, or you have to plead guilty on that. Why don't you just reduce the load on yourself? You be innovative. Do you mean to say there aren't any judges or any administrative judges who are engineers or doctors? They are. Give them a chance to bring out their knowledge, bring out their experience in life, bring out their educational experience and implement that. Why don't we take it when somebody comes from that field? Let us also, as a society and as users of this system, let us also accept it. Let us not say like, oh, now I have to invest in a laptop, now I have to invest. No, mobile phones, you can join via mobile phone. Things are simple, like, you don't have to take a days off. A person from who has to travel, like let us say from a tier 4 town, he doesn't have to travel to a district headquarters to just attend the case. He could rather take from his mobile and attend the case while working in his fields. If a farmer is a land dispute is fighting, he could just pick up his phone and just log into the link given provided by his counsel and present himself and see to that what is happening in his cases. That would be wonderful choice. So as you said, So efficiency of the courts, how do we determine the efficiency of the court, is the challenge that every country will have. So when judicial efficiency has to be measured, will it be measured via judges per cases resolved, or judges cases resolved but it was appealed? How do you take it? So it is a very challenging aspect, and how to determine the efficiency will always remain a gray area. So we will have to explore that option. Maybe we should call upon somebody who has been in the system for a longer time than us to understand that, and come out with some suggestions for that. Over to you, Manju. You have got anything to say on what me and Sham, put our points for?
Yes, sir. As both of you discussed about the standards and also talked about the talents and talked about the technology which can be utilized. When it comes to standards and the sensitivity, I would like to bring few points over here. We have come across a respectable number of judges in the past who remain still unforgettable for their deep knowledge of the law and sensitivity they possessed. And I would like to quote an example, Justice V.R. Krishna Iyer, where he quotes that litigants are legal patients suffering from injustice, seeking healing for their wounds. So, what a kind of sensitivity the man carries. A lot of respect to him, and whereas and also the standard what he has set is also pretty much high. And whereas when we quote an example of today's judges, I would like to um, uh, um, share a quote or a comment which was passed while dismissing the public interest litigation filed by Vishal Tiwari versus Union of India, wherein the request was to reform the domestic violence law, which which was mainly to prevent their misuse in the lights of suicides in India, which is happening due to family problems, and as the protection against domestic violence is not gender neutral. So while dismissing that particular plea, they say that society must change. We can't do anything, and parliamentary laws are there, and we are just going to follow it. So these kind of statement seems that do they really carry some sensitivity in them, or are they not accountable to this society? Uh, so these are the questions which come. So with these kind of standards, I see that the standard has been pretty lowered. It's I don't see any. Sad to say that the quality is not good, to put it in a plain language. And also when I say the quality and the standard has come down, I can quote a recent incident which has happened in High Court of Karnataka, uh, in the Justice Devdas bench. Uh, there was a petition which raised a serious doubt on the credibility of the trial court decision, where trial court cited the manufactured judgments in its order. Means the judge has cited a non-existing judgment which is not even presented by the petitioner or respondent. Pro- Probably seems like with ChatGPT has got those three judgments and he has given an order. So
Yeah,
so
Manju, for
this
that,
really
Manju, for that, I would say, like, the technology we use, I always referred we could use the technology. But if you look at it, now the argument will be, or the debate will start on whether the technology is a boon or a bane. So it
no
could be used
see
both
it
ways.
see it should be for our for efficiency we can use, but not to make my job easy. It's that means that who is using, what kind of quality that person has while using that particular technology, that also does matters. So this
True.
is where I just want to hear more on it, wherein our legal standard, are we not maintaining any kind of legal or moral standards over here? with such examples or things coming, means emerging out of, wherein the judge, they don't even want to they are citing a judgments which are not even existing. Come on, this is high time. So what kind of quality we are having if these guys started giving judgment by going through chat gpt or ai, or so,
No, no,
or
you're,
by
you're
going through whatever newspapers headlines, if they are going to start giving judgment based on that, so so what kind of justice we can seek from these kind of low standard low standard
so,
judicial system?
so there is a saying or poet Rahat Fateh Ali Khan and some Rahat Indori, not Fateh, Rahat Indori had a saying which said that if there is a fire in a lane, it will not see which house it is burning. In the same way, very well known proverb that if there is a fire in the forest, it will not see how tall the tree is. It will just burn, right? So if such
While you
things
say
are
that, Sham, I would like to interject. While you say that statement, how tall the tree is not there, but also I would like to remind you of the statement saying the straight trees are cut
so
first.
cut first. No, absolutely right. Absolutely right. But see, it is about understanding and setting the system right. So when Chanakya says that the tall trees or the honest trees, honest men, the tall trees are cut first, the same way honest people are or very straight people are taken for trial first, right? But his statement comes with a background assumption. That assumption is you have a leader, you have a Raja, you have a king who is running on his morals. And when that happens, you need to set yourself right into the system. You cannot have everything in a right procedural manner always. That is where he wanted to bring that in. But I want to call out, and I would really appreciate all the effort by Indian judiciary that they have put in making things easy. There are many honest people in the system also, right? Here, I think what we are trying to discuss is that the exceptions which are taken in certain cases, the exceptions that are taken when certain genders approach, the exception that is taken when a certain class of people approach the system, and the procedural delays that happen in delivering the justice, some closeness that we see in adapting innovative ways, and the retrospective that one has to do to understand why the system is failing. These are the points which we want to call out. But uh, you and Manju has brought a very wonderful aspect, and that once again makes me point to the core. That core is, should judges be made accountable for drafting incomplete or improper laws? Were they given an opportunity to draft it and bring it back to the system? Yes, we know there is a law commission who helps in articulating, drafting, and presenting it and refining it, and that is where Parliament brings up, enacts those, brings those acts, and then makes it into a law. But who exactly has to be held responsible for procedural delays? Who has to be held responsible for incomplete or wrong drafting of the law? Who has to be held responsible if number of criminal cases increase in that particular demographic? I would say it is the leader of that place. It is the legislator of that particular place. We need to start ranking the legislators. We need to start ranking our leaders, taking the total number of cases coming from the demography from where they come from, which means they have failed to make the system safe and secure for justice. They have made the system incapable enough to handle and deliver justice in the right time. So make them accountable, rank them. The best person, the best legislator is one where lesser number of cases are being registered in their demography, lesser number of crime is being committed, because there are procedures, there are equipments, there are tracks to capture the actions, the illegal acts that happen in the system. Once you start setting that right, then you will have a very confined world of corporate where things may go wrong. You have a very confined world of trade and business where things may go wrong, and then that can come to judiciary. But at least a common man will be very happy, because a lot of these cases which are coming into the system are from the common man, are from people who believe that they have been deprived of something and they need to have that justice. So judiciary alone cannot be responsible for this. Judiciary has to be made responsible along with administration, along with legislation. Legislators need to be ranked depending on the number of cases that come in. Many factors, there can be many factors. Along with that, how execution happens, even that plays a very vital role. And Dr. Swami sometime back made a very good statement about media as well. Most of the time our media gets so enthusiastic that they run their own trial and doesn't allow the judiciary to have an unbiased view of certain subject. And this is most commonly seen whenever there is a case related to a lady or a woman comes into limelight. And during such cases, most of the people will have a candle march carried, or they will get onto the road, and media will run its own trial even before judiciary or investigating authorities come up with their findings. It is a collective responsibility as a society. If we have to get justice in the system, then we have to be part of that system. We cannot exclude ourselves. Every common man should come forward to contribute and deliver and help deliver justice in the system. Morally, we should elevate ourselves. We should rank what type of leaders we are electing. So that also plays a very vital role. We also need to see that our execution body, police and enforcement directorates or CBI, CID, these type of wings need to have right powers given, so that people also have that fear of getting executed if they have made something wrong. So it is a collective responsibility. Larger responsibility falls on judiciary because they are the experts and they are the subject matter experts of that particular system. So they have to contribute more. However, it will be a collective responsibility, and we have to see this from a holistic side. We cannot just take one segment and put blame on them alone. It has to be looked from an overall point. That is what I want to call out. Thank you. Over to Dr. Veeri and
Agreed.
Manjunath for closing
Agreed.
comments.
Agreed with your viewpoint, Sham, saying like judges do a fair good job. Their work, judiciary is as judiciary as such has not been the key person who makes the law, but the legislative makes and the judiciary follows. But I would also say the behavior of the parties, also counts. That is where the society and the individual comes, and the education that comes into picture of the societal education. I don't mean to say individual education, a social behavioral education to the person. When is the society ready to educate its people? When should a person approach the courts? When you should go? So going by that, if I am correctly recalling, there was a book written by Kafa France. It was called as Before the Law. The book was called Before the Law. In that he says like when there is a law, there is the law. Before the law, there is a doorkeeper. A man from the countryside goes to the law and says, I want to enter. So the doorkeeper says, no, I won't allow you to go because I cannot allow you now. So this keeps on going up. The man is so, his journey of life is over. And then he says, when will you allow me? He says, later. So the man is made to wait at the door for long time. Such an important thing. The man gets equipped by himself about the law, and he says, would you now allow me? Yes. But by the time the man is about to die, this is what the author wrote it at that point in time. So if you look at it, this was somewhere in 2013 or so what was published. It was also, I think it was one of the speeches given by one of our earlier retired judges. So if you look at that way, so don't we think, or shouldn't we come to a conclusion saying, like, in addition to the judges and the judiciary and the legislative, they have to do a fair job. Judges may also provide insights to the functioning of the courts so far, how they are doing, so that publicly everybody knows how it is functioning, which most of us don't have it until we go to the court. And the behavior of the party must be driven by incentives created by the law itself. So you should create an incentive by the law to the party itself, both sides. Then only they will see whether they should come or not go. There is no quick check and balances that is available. So there should be checks and balances that has to be upbeat in the beginning itself. Then a person decides, should I go or should I not go? There should be a just like how we have in the high courts scrutiny branch, I think, where they scrutinize the documents that we file and say these are the objections, please go rectify it and come. Why don't we have a pre-litigation checks, like, okay, guy, a petitioner or plaintiff, bring out your evidence, these are this, okay, let us call the other guy, come here, sit, these are the evidence this guy has got, do you have anything that can counter these things? Okay, let us see this. The judge decides then and there itself, okay, fine, which is heavier, so this holds good. But instead, we run just to prove these evidences, to put forth into the courts itself. It takes years together. That's the challenge. That is clogging the system. So we have to, the behavior of the parties, if you incentivize these people who are coming to the courts in one or the other way, I don't know. I cannot say how it can be done, but there should be somewhere. If you lose also, you're going to win. That's the way it should look at it. Then I think people would not approach or would not drag the cases for such a long time. After all, we the Indian law has been diverged from other common laws. We have diverged from other common law countries. We have evolved ourselves one, because I think, if I have read correctly, most of our earlier system, as Manjunath has written in his paper itself, he said, like, we were through a different way of panchayats, and that's the way our system was working. The way we were leading Indian ancient system was traditional justice. It was more of dharma, panchayats, and local governing bodies, small local governing bodies. So now we have lost those things. Nobody is going on the righteous part, but they want always looking at the winning part. So most of the time, though there is a certain role to be played by the judiciary and legislative, I would also say it also behavior of the parties that also counts into this. So it is a collective effort, as you said. I ask Manju to do the honors of closing what he would agree with us. Please, over to you,
Um,
Manju.
yeah, it was a nice review, and also both Shamsar and Viriza, you both came up with new insights and also suggestions where things can be get fixed. Um, but but what I would see is public has already lost trust in the current Indian judicial system. That's where uh, a massive social movement like justice is due is going on, and moreover, the clogging of Indian judicial system. It is not just the failure of the system. Actually, it is driving people towards a great distress, and which is leading to genocide in India. And also, if we see these 5 crore 21 lakhs of cases pending, which would take around close to 500 years to clear those backlogs, and if still the judicial system and our legislatures are not taking up any action, I uh, what I would see is, I'm not sure whether should I say this on here or what. Uh, people are now showing up their aggression upon themselves, where they see themselves as helpless, and in order to send a message to the society, things are happening like justice is due movement. And days are not far wherein we can, recently in Iran, two judges were shot dead, they were fired. I So people may take up laws in their hand, whether it's right or wrong, because because system is pushing uh, pushing their people towards it, where the system is totally failed to take care of the citizen. So those were my thoughts. Thanks for your insights as well. So any closing comments on this, where I see that
I,
people would really take laws into their hands. The days are not far, sir.
no, no,
I'm afraid on that. I'm really afraid on that. Wherein I don't know where it might create an anarchy in the entire system.
no, absolutely right. See, I think two things drive peace in society. Okay, number one, clarity. If you have clarity of what you are going to achieve or what you are going to lose, it will keep you at peace. Okay, one need to have clarity. But what is happening is, if we look into the way the cases are being handled, and on a similar situation, the inconsistency of judgments, and keeping on reinventing, repeating the same situation, the same case in a different manner at different levels of courts. A simple example is to determine whether limitation can be applied on DV Act or not. It took almost 15 years, right? So uh, someone who would have read that and who would have thought that there is limitation, and think about the cases where it has got dismissed depending on certain limitation in the past. So should those cases be considered as justice delivered or justice delayed for a very long time, and then they are reapproaching? So it puts people under a lot of confusion. If people have clarity, they will be able to do it. They will be able to come up with peace. They will have confidence in the system. But because we are having inconsistency in judgments, clarity is being taken away. People are losing trust. That is number one, which I think. Second, uh, with all due respect, I don't want to say this, but somewhere I feel there need to be still a bit of more accountability on the whole system. Without accountability, we cannot expect a system to exist. Okay, so I know that is one of the supreme systems which is delivering justice, which has been curated to cater to common people. And if that system doesn't have clear accountability, it becomes very challenging. So, of late, we have seen situations where people are raising questions on the accountability of the judicial system. I once again say it is not in my capability or capacity to even comment on that. But as a common public, I would feel that a system need to be accountable. So if you have inconsistency, it will create a lot of confusion, no clarity. No clarity results in dissatisfaction, disbelief. Lack of accountability once again results in disbelief. And when all these things are running, if something happens in a person's life and he faces the system, the perception with which he is already entering into that system will drive him to think 99% negative, and that negativity will be taking the next course in that way itself. So unless we set these things right, we cannot expect to have justice. But at the same time, I would really want to conclude saying what you started with, that is, justice is due. So why the movement started? The movement started with just one basic assumption, one basic proverb, which once again King Martin Luther has said that freedom is never voluntarily given by the oppressor, it must be demanded by the oppressed. So, justice is due is a movement representing this proverb, representing saying that people felt they are oppressed, people felt that they are not getting justice, people felt that it is the system is not capable enough, the society or the framework is not ready enough to deliver justice to them. That is why justice is due started. Now it is on everybody's shoulder, it is on everybody's head now, that they should think and they should evaluate what will happen if they get into this situation. Will there be just another story and a note writing justice is due, or will there be a positive mindset which opens up the gate of hope towards our judiciary system? With this, I would like to close so that people can think what path they want to choose. A note once again with justice is due, or a hope to the coming generation. Thank you. Thanks, everyone.